My key message was that we need to understand very carefully what exactly new technologies mean for labour law. I don't myself believe in a sweeping hypothesis that would say that technologies are fundamentally changing the nature of capitalism or the nature of work, although I do accept that the context within which labour law rules operate is changing and labour law must change and adapt to still work effectively. But my basic message is that in a market economy, labour laws are needed and are to be seen as an input into production and a resource. So there should be ground for agreement between employers and trade unions on these questions. Technology changes some things, but it doesn't make labour law redundant. And in particular, if there is to be a transition to a new world in which the standard employment contract no longer operates, and that's perfectly possible over the long term, but not, I think, in the immediate future. If that transition is what we're going through right now, we need to be clear that the transition should take place on the basis of respect for social rights and respect for the dignity of labour and respect for voice at work. Now, there are some technical issues about how one defines an employment unit, about who is an employee, but these seem to me to be manageable by labour lawyers and by people with technical expertise. The bigger question is, can we still have labour law and a welfare state as technology changes the way that work operates? I think we can. That was my message. And I think the message is we shouldn't get too carried away and should be very careful about extrapolating from trends whose outcomes we can't entirely foresee. So I said in my talk, there's nothing new under the sun. That's a bit of an exaggeration. Some things change, but we have been here before. We need to look at what history teaches us, and we should, I think, be cautiously optimistic about the prospects for labour law going forward.